Hello friends, in the series on the income tax cases, today we will discuss the case of PHILIA Estates Developer Private Limited versus Assistant Commissioner of Income Tax. This case has been reported in 104 ITR Tribunal Short Notes 15. The matter has been decided by Delhi ITAT F bench and the date of the judgment is 2nd May 2023. This case is regarding section 56 subsection 2 clause 8, which says that if the assessee receives any interest on the compensation, then that interest is taxable under the head income from other sources. And there is one more section, that is section 57 clause 4, which gives a flat 50% deduction from this interest. In this case, the moot question before the ITAT was that whether this interest is taxable under the head income from other sources or under the head business income if the assessee is engaged in the business of real estate. Meaning thereby that whether the nature of the business will affect the head of the taxability. This was the main question in this case. The assessee was in the business of real estate, his property was acquired, and accordingly the assessee received near about 74 lakh interest on the compulsory acquisition of property, and the assessee included this income under the head income from other sources and claimed a flat percent deduction according to the provisions of section 57 clause 4. When this matter was under the scrutiny before the learned assessing officer, it was the viewpoint of the learned assessing officer that since the business of the assessee is of real estate and the property of the assessee has been acquired by the government, so this is in the nature of business, and whatever the interest is received because of this compulsory acquisition, that should also come under the head business income, and the standard deduction of 50% should not be allowed to the assessee under section 57 clause 4. So the assessing officer denied the standard deduction of 50% under section 57 clause 4. When this matter came before the CIT appeal upheld the order of the assessing officer. As we know that in maximum number of the cases, especially when the regime of this faceless has started, that the orders of the assessing officer are being as it is upheld by the CIT appeals without any much application of mind. When this matter came before the ITAT held that it does not affect the taxability of the interest on compensation that the assessee is involved in the business of real estate. The ITAT held that section 56 subsection 2 clause 8 read with section 57 clause 4 have the overriding effect over the other provisions of the Income Tax Act, and even if the assessee is running real estate business and his property is acquired compulsorily and consequently the assessee receive any interest, then that interest will be taxable under the head income from other sources under section 56 subsection 2 clause 8, and accordingly the assessee will be very much within the four corners of law in claiming a 50% deduction, a 50% standard deduction according to the mandate of section 57 clause 4. Friends, we have seen that whenever assessee classifies his income into any head, then the department just tries to drag that income into another head, because in another head the tax effect is coming higher. But that should not be the approach. The mandate of the provisions of the Income Tax Act should be seen in the true sense, and then the decision should be taken. The decision should not be taken on the point that the tax liability of the assessee is increasing in one head or the other head. At the end of this video, once again I am repeating the name of the case, the name of the Case is PHILIA Estate Developers Private Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 104 ITR Tribunal. Short notes 15. The matter has been decided by Delhi ITAT and the date of the judgment is 2nd May 2023. Thank you, friends.